Bill Henshaw here again, your friendly local constitutional coop, San Francisco. And I'm going to be talking today about some devices and procedures I've developed to get us into the U.S. Supreme Court, and very probably in the original jurisdiction where we can get some real changes, not that appellate BS side, whether, and that's a real problem even today, by the way, but back in the day, that's what happened to William H. McCardle because his attorneys went there under the Habeas Corpus Act of 1867. And I will credit them with not knowing at the time what we know now, but that was another war act of Congress. And the court ruled against the Reconstruction Act of 1867 and effectively ruled against the 14th Amendment, but were not allowed to announce the decision because Congress removed the appellate jurisdiction from the court, which they think they have the right to do. That's a video for another day, but I certainly disagree with that. But it happened here, and it changed the course of American history because of it. We can get it back because that's a big reason why we go under the original jurisdiction, and we have a right to be there. And the Supreme Court said that in a case called Collins v. Virginia, 1818. Oh, that's old law. They don't use that anymore. Hell, they don't. The current justices have cited this case several times over the course of the last 4 terms. And a big quote from this one, dead bang off the top of my head. The Constitution gave to each person a right to present his case to the court of the nation, no matter how small the claim nor how little interest the community in its outcome. The framers of our Constitution thought it necessary in the interest of justice to create a tribunal as superior to influence as possible in which that claim might be decided. Plain English, easy to understand. That's what we'll be doing, and the justices get it now. So when we get there, in the original jurisdiction, and there's a couple of different ways to do that. They're going to know, and I think they know they have the sworn duty to take our case, hear it, and decide it, because that's the way it was set up to work. So it's just good news all the way around. And then you get to other things. For example, we have a case called Kamezo Kawada. Now, he was a Japanese, and this is 1942, I believe, is the year. And he gets an original writ of habeas corpus issued by the U.S. Supreme Court. That's virtually impossible to do, but he was able to do it, and note the time frame. He'd been here for 40 years, came over around the turn of the century from Japan, and yet with the events in Pearl Harbor, and FDR knew about that long in advance, and then knew really back in the late 1920s. I'll do a video about that later. But Kamezo Kawada, being Japanese, was now treated as an undocumented enemy alien, and he had no way to collect the paycheck he was earning working as a longshoreman off the coast of California. No judicial courts. That's exactly what they think at least lawful de jure sanguinis state citizens are. Undocumented enemy aliens. We have no rights to come into their courts. And they're right, because they're not judicial courts, they're administrative tribunals. We do, however, have the right to a judicial court from day one. And I think that Africans and Asians do too, pursuant to at least Article 2 of the Northwest Ordinance of 1787, as reenacted by the first Congress. Now, if that's the case, those courts have to be there. But they're nowhere in sight. And that's how Kawada got that original writ issued by the U.S. Supreme Court, because he had no remedies. Neither do we, and we should be able to do exactly the same thing, and for the same reason. Now, we'll see how that plays out. But with the record I have, and that's what you get with my material, by the way, send me an email, youwinnincourt@gmail.com. We not only say all of this with attitude and with authority, I can back it up with a daunting amount of relevant, admissible, documentary evidence up the wazoo, in concert with my expert witness a cappella testimony on 230 years of the Constitution, laws, and history of the United States. We won't even have to file anything in your case, and if we do, it won't be very long, because they can't have me coming in there and educating a jury, which I want to do quickly, and then run the risk of the perps getting cross-examined by me on the witness stand in front of the jury, unfiltered by one of their state bar association attorneys. That gets the checkbooks out. That's how good this is. So that said, remember to subscribe, like the video, tell your friends, get the word out. The quicker we move forward, and with the U.S. Supreme Court, the quicker we make this happen. Thank you.